Well, this is one of my favorite topics. I spend a lot of time helping people in this particular area. Let me just ask a couple of questions to get started with. How many of you here in the audience have people who owe you money right now? Everybody except you. Okay, that's okay. How many of you owe people money? Few of the same people. Very important lesson here, by the way. How many of you here have ever been in bankruptcy? Okay, and just try to, not to put up your hand too high because we are videoing this. You don't want people to be tracked later on. Okay, nobody. Well, that's good. If that is not happening, you're not doing half bad. The reason I ask the question is because as a lawyer, I work both sides of the field. Of course, you know, all lawyers do that. But in my case specifically, I represent people who owe money, debtors, and I owe people who are owed money, creditors. And since most of you are in the creditor mode, let me just switch to the other side for a second and talk about what it's like to be a debtor, what it's like to owe people money. Because it's like anything else. You have to look at things from their perspective. It's no secret we're living in tough economic times right now, and a lot of very good people owe lots of money. Owing money is not 99% of the time a moral judgment. And I'm going to make that point over and over again. Even very good people get into situations where they simply owe too many people too much money. Whenever I'm confronted with a client like that, I can tell you one thing. Here's one thing I can tell you about any debtor, anybody who owes money. There's always some money available to pay debts. Very rarely do I find myself in a situation where a client just has no money to pay anybody. Usually, 9 times out of 10, there's some money to pay some people. It's just that there isn't enough money to pay everybody what they're owed when it becomes due. Okay? So in a situation like that, what we do is we make a list of all the creditors, and what we do is triage. Now, some of you know what that term means. It's an old French term. It simply means to divide into 3 parts. We create 3 piles, and we put creditors in each one of the 3 piles. The first pile, which I'm going to call pile number 1, people who are essential to the operation of the business. People who, if they don't get paid on time, they'll shut down and the business will go under. And the poor fellow's going to have to file for bankruptcy because of that. So, for example, key suppliers. Perhaps a key employee that knows all the customers and knows them, frankly, better than the owner of the business does. You know, paying that salary might be very important to that particular debtor. Lawyers and accountants are usually in that pile. I find myself more often than not in pile number 1, although not always. People tend to be afraid of lawyers. They know what we can do to them, you know, if things don't go right. So lawyers and accountants. If it's April 14th, you know that the accountant is going to be paid on time. That's going to happen, okay, for just about any business that I'm aware of, or March 15th if it's a corporation. So that's pile number 1, people who are essential to the business. Pile number 2 is the pain in the neck pile, for lack of a better word. These are people who are not essential to the operation of the business. They don't belong in pile 1, but they're making such a bloody nuisance of themselves that it's worth it just to pay them to get rid of them and get them out of your life. Okay, I can think of much more horrible words for these people, but pain in the neck suits me very, very nicely. Usually they're very small amounts of money. And by the way, if you don't think that this is real, I had a situation just about 2 days ago. I had a client call me. This is a client that started in business 3 years ago. I won't say what they are. They're in the marketing business in certain ways. Last year they had $1.5 million in revenue and a gross margin of $500,000 on what they did. And they were calling me because somebody was suing them in California for $15,000. And they were wondering whether it would be worthwhile, asking me if it would be worthwhile to hire a California lawyer and fight the suit, or take a default judgment and then hope that they don't sue them here in Connecticut. And when they finished this whole thing, I said, dude, you made $1.5 million last year. This is a $15,000 problem, and they'll probably settle for less than that. Dude, why are you even thinking about this? Call them up and settle the damn thing. You know, this is less than 1% of your last year's revenue. Why are you taking this hit and risking damage to your business? If these guys sue you in Connecticut, it's going to be all over the papers. Why are you going to risk that for a lousy $15,000, and you can probably even get that knocked down? Some people don't think sometimes when they get into situations like this. So the pain in the neck pile is important. Then there's pile number 3. Who lives in pile number 3? Everybody else who is not in pile number 1 or pile number 2. Okay? This is important. That's where most of you reside, okay, is in pile number 3. So if you get nothing else from this program, okay, I've told you now how debtors work, especially debtors who are working with lawyers and accountants. Everybody does the same thing. We do the same triage pile. If you are not in pile number 1, if you are not, because I'll tell you, here's how things play out. Pile number 1, those debts almost always get paid on time, almost always. Why? Because they're essential to the operation of the business. If those people shut down, the business goes under. Okay? Pile number 2 people, the pain in the neck people, get paid some of the time. Pile number 3 people wait. And often they have to wait for very, very long periods of time. These are the nice people, pile number 3. Okay? They're people who are willing to wait, and hopefully they're able to wait. So, if you get nothing else out of this program, my lesson to you is, if you are not in pile number 1, when somebody doesn't pay you on time, you have a receivables problem, if you are not in pile number 1, you have to do everything you possibly can to get yourself into pile number 2. Because otherwise you're in pile number 3 and nothing's going to happen. That's the common sense of what we're going to be talking a little bit about tonight. I'm going to teach you some wonderful strategies for how to get into pile number 2, even if though you are not a pile number 2 kind of person. Okay, which is important. Not everybody's a pile number 2 kind of person, but it helps if you are. Okay, so let's get started. Okay, nothing, and let me just say this at the very beginning, nothing eats at your guts when you run a business of your own, like when a client doesn't pay you or a customer doesn't pay you on time. Okay, nothing eats at your inside. Nothing burns your breakfast. Like when, and especially if it's somebody that you've dealt with for years. Someone who has always paid their debts, and now all of a sudden the bill's late. You know, it's 32 days and they haven't paid. Okay, nothing burns your breakfast. It's very easy to take this sort of thing emotionally, and that is a major, major mistake. Okay, the first thing, there's a famous old Spanish saying that revenge is a dish best served cold. And I love that saying. The first thing you have to do is take all of the emotion out of it. Okay, because that gets you into trouble. First of all, it's not going to get you paid any faster, number 1. Number 2, it isn't a personal thing. I know people who are personal friends with people who owe them lots of money. They can keep the personal and the business thing separate. You know, owing people money is not a moral judgment. It doesn't mean the person's a bad person. It just means that they're having financial difficulties. That's all that means. It's not an ethical judgment on somebody. Also, too, when you get emotional about this, you can make some mistakes that can actually get you into a lot of hot water. Okay, when you try to, especially if you decide to adopt what we shall call creative techniques to collect the debt, you can get into some serious trouble with that. Okay, when it comes to debts, you have 3 goals. Number 1, keep them at an absolute minimum. Avoid, an ounce of prevention is worth a pound of cure. Believe it or not, there are some very simple things you can do that will reduce bad debts by at least 95%. And we're going to talk about those tonight. Secondly, keep small receivables from becoming big ones. This is one we're going to emphasize a lot. Big receivables problems almost always start as little ones that get out of control. And that's when you got to stop them, is when they first happen. That's when you have to arrest the problem in the bud and not get into a situation where you're doing 18 or 24 months worth of work for somebody who owes you money. Last but not least, treat problem clients ruthlessly. Now, unemotionally, I said that a few minutes ago. I'm not saying you should get emotional here, but you do not tolerate bad debts. Getting a reputation for being too tolerant of bad debts is a bad thing, and it will hurt your reputation in the business world. Okay, we're going to learn, as somebody very, very, very high in the business world once told me when I was first starting out, there's a very big difference between being ethical and being nice in business. Being ethical in business is essential. You have to be ethical. People have to trust your word. You know, people have to know that they can rely upon you. You're dependable, yada, yada. But being nice can get you killed. And I'll take questions at the end of the program if that's okay. Let's talk about the first step, first of all, avoiding bad debts, keeping them from happening in the first place, okay? I always counsel clients, try to get some money up front. Whenever you get a new client for the first time, some of the people that I deal with are not the most sophisticated business people in the world. A lot of people that I work with are people who have never run a business before, so they don't really know what they're getting into. I have to let them know that I am not their buddy. I am not their friend. I'm a nice guy. I mean, I'm funny. I'll make you laugh. You know, I mean, it's not going to be painful to deal with me. You know, I try to keep a good personality about me. But I also want to send the signal, too, this is a business relationship. I am going to be doing work for you, and I expect to be paid. That's the deal here. So I always ask for some money up front. That gets the client into the mood of that does two very good things with a client. Number one, it sends them the signal, first of all, that this is a business relationship. This is not just a friend, a buddy that I'm calling upon for advice in a certain area. This is a business relationship. I expect to pay. It also sends the signal that this guy is a real hard nut and he's not going to tolerate late payments. You know, a client that cannot pay money up front is, to me, a problem, especially if it's the kind of thing where I'm going to be doing a lot of the work up front. That makes me nervous. I don't want us to get too far ahead of where the client is in terms of payment. We'll talk more about that a little bit. Get an airtight contract that leaves the client with no wiggle room. This is very important. I cannot tell you how many bad contracts I see that my clients do. 90% of the time, when a client is owed money by somebody, I look at the contract, and you know what? The contract almost gives the person the right not to pay on time. Isn't that horrible? Isn't that horrible? I mean, I cannot tell you how many contracts I see where the person, especially construction, the construction people, the contractors, they are absolutely the worst here. They're very good at spelling out what they're going to do. They do the punch list, they do the bullets and all this stuff, and they say exactly how much it's going to be for this kind of work, and 2 guys are going to be doing this, and this is their rate, and whatever. But they never say when payment is due. The contract is silent. Or it says something like, the payment will be due upon client satisfaction. You tell me, when is a client satisfied? Never. Never. When is it? Any website people here? Any web developers, you know, social media people? When is a website finished? Answer, never. I've been working on my website for 20 years. You know, it's still not done. It never happens. Rule number 3, stop working or hold back product the minute bills become overdue. Remember I said a few minutes ago, big receivables problems almost always start as small ones that get out of control. The minute you see a client is having trouble paying or a customer, stop working. Stop digging that hole. Don't make it any deeper than it already is. Call the person, work something out at that point. Let them know you have zero tolerance for this kind of thing. You're a small business owner. Whether or not you can feed your family depends on whether or not those bills get paid on time, and he needs to know that. I am utterly ruthless about that. You know, I tell my clients up front, my bills are net 30. On day 31, you'll get a nice little email from me saying, hey, this thing is, I haven't received this yet. If you've already sent it, ignore this. If not, you know, please, you know, turn it around within the next 24 to 48 hours. If I don't hear from the client by a week thereafter, I stop working. And I call that person and say, hey, what's going on here? You're obviously having some trouble. Talk to me. What's going on? That's what I do. I do not want to get lulled into the situation, oh, well, he's probably just having a bad month. He'll pay it next month. Because next month, I'm going to have another whole month's worth of work, and that bill is going to be twice as much, twice as hard for that person to pay. It's very easy to get into these holes. And then, this sounds stupid, but the last bullet on there, don't do business with crazy people. You know, it's amazing to me, whenever a client of mine has problems with somebody, almost always when they call me, the first words out of their mouth, Cliff, I knew it. I knew this person was going to be trouble. This person was a problem from day one. I said, well, okay, why didn't you trust your judgment? You know, you've been in business a long time here, Joe. You know when you're dealing with a weirdo. Okay, what happened here? You know, did the weirdo, you know, radar just shut down here? You know, believe it or not, 99 times out of 100, you can spot the problem clients before they happen. You can. They act weird, they act funny, they say things, especially in my field. Here's the one I have to watch out for. Cliff, you know, you're the third lawyer I've dealt with in the last 3 years. The last 2 guys were a bunch of bozos, but I can tell by your website, you're in a different league than them. I know I'm not going to have the same kind of problems. Yeah. Inevitably, I say, okay, well, who were these 2 other attorneys? Inevitably, they're very good, reputable attorneys that this person was dealing with, okay? So I know the problem is not quality here. The problem is they didn't get paid, and they got shut down. That's why I am the next victim in line for this person, okay? So be careful about that. Your sense, even if you haven't been in business for a long time, your stomach is a lot smarter than your brain. in a lot of ways. If someone just is coming on to you in a strange way, you do not have to do business with that person. I'll tell you how I handle it. Whenever I think I'm dealing with a flake, somebody calls me and it's clear from the conversation that they're not playing with a full deck. I mean, I'll tell you, this is how I handle those situations. I'll say, well, I really would love to help you, Joe. This is the kind of work that I do, but just to let you know, I'm kind of on deadline for my next book, and I'm really not going to be able to take on a lot of new business for the next, 3 or 4 months or so. Here's another attorney here in town. His name is whatever, Charlie Smith. Here's his number. Give him a call. If you want, tell him I sent you. I've worked with this guy for years, and I know you're going to have a very good experience with Charlie. Okay, and then maybe in another few months, if I have the time, I'll be, you can come back. Once I get this book behind me, I'll be able to do a lot more legal work. Okay, now, that sounds great, right? Who am I sending you to? Am I sending you to somebody I like? Answer, no. I am sending you to the attorney I hate the most in the local bar association, my worst enemy. That's who I'm sending you to. I want him to have you as a client. If I think you're a flake. And by the way, I hope you don't think less of me because of that. I hope you don't, think less of me, but that's kind of the game here. If you really are confronted with a total loser here, why not sick them on your worst competition? Hey, nothing illegal or unethical about that. They're big kids. They can if they're good, they'll spot the same thing that you'll spot. And of course, they know it's coming from you, so they're not going to send it back to you. I always worry when another attorney refers me business. Actually, whenever another attorney, especially an attorney that I know can handle the work, I always kind of wonder what that person thinks of me. That's one way that I'm kind of on notice that maybe I'm not that attorney's favorite buddy. Anyway, okay. Sorry, there we go. Okay, so now let's talk about that airtight contract. Without a good contract, you have no hope of being paid. If somebody can drive a truck through that contract, you're going to have problem getting paid. Okay? Your contract has to be absolutely clear about how much you are to be paid. Now, most contracts are pretty good about this. Most people know to put in their hourly rate, their per diem rate, however it is they're going to be billing the clients. Okay? But here's the big one: when payment is due. Out of every 3 contracts that I look at, 1.5 of them do not say specifically when payment is due. The language gets fudgy and dicey. It says things like, payments will be due 30 days after invoice. Doesn't say when the invoice is going to be rendered, however. Okay, payment is due 30 days after invoice. That's still not clear. Payment is due upon client satisfaction. Payment is due upon substantial completion. Payment is due upon the achievement of certain milestones by mutual agreement. What's going on here, folks? You are giving the person an excuse not to pay you on time when you have funky language. I insist on crystal clarity. Believe it or not, I can live with a lot of ambiguous language in a contract. I'm not one of those people who insist that everything has to be nailed down with specificity. I've been doing this work for 35 years of my life now, and I know when you can give a little bit on contract language. But the one thing I never tolerate ambiguous language is payment terms. I want to know with crystal clarity when that payment is due. If payment is not received within 30 days, on day 31, you can sue this SOB. That's what I want to be able to tell a client. Okay, and if it's not specific, I won't be able to do that. Very important point, always state in your contract, interest will be charged on overdue payments. You may not realize this, but legally, you cannot legally charge interest on overdue payments unless you tell the client or customer up front that you are going to do that. Believe it or not, that's considered a violation of the usury laws in Connecticut and elsewhere if you do that. So always in your contract, or if it's an invoice, a purchase order form, I'm not saying you have to have a formal contract with witnesseth and whereas clauses, but if you're doing it like a printed form document, make sure there's language in there that says interest on overdue debts shall accrue at the rate of 12% per annum or the highest rate allowed by law if less. That language is very boilerplate, and it should be in every one of your invoices, contracts, whatever you use as a document that will support payment of money. It should always be in there. Whether the business owners will be personally liable if the companies don't pay. You can't get away with this if you're just selling goods or anything like that, but if you're doing a service business, when I do a retainer letter, I always put a little line in there that says that while I may accept payments from a corporation, LLC, or other legal entity, I view the person to whom this letter is addressed as my client, and I expect that that client will be personally responsible for any obligations hereunder. Now, some clients do fight that. And of course, if it's a client with a large corporation, an established business, I might take that language out. But if you're just starting out and you're forming an LLC, for just you, okay, I don't want to be in a situation where I have to rely on the LLC for payment. Okay, I want your house, quite frankly, if that payment doesn't come in. So I throw in language, it's a little funky language that says that, while I will accept payment from your corporation or LLC, you are the client and you are the person that I am looking to for payment, et cetera, et cetera. Then last but not least, mediation or arbitration of disputes. There should be some language in the contract that says how you're going to resolve disputes. I don't really care what it says. There's a million ways you can say these things. But there has to be something in there that says, if we do get into a fight, how's it going to get resolved? Especially construction contracts. Because let's face it, I mean, if you're in the middle of a construction project, it isn't really, let's put it this way, you can put this language in the contract, but it's not very practical to say that you'll arbitrate all disputes. I mean, the building's half up. The superstructure is getting soaked every time it rains or snows. I mean, you can't be in a situation where you're taking 6 months to arbitrate dispute. There has to be some other way of dealing with that, about how to handle disputes. So that is keeping debts at bay. Now you have a problem, okay? Your contract, despite the fact that it was drafted properly, isn't working. Somebody still wants to not pay you on time, okay? Now we have to talk about the 4 steps of collecting an overdue debt, and there are 4. Make a demand for payment, number 1. Try to negotiate a solution. Try to work something out with the client, Number 3, mediate or arbitrate if you can. We'll talk about the differences between those in a second. And then last but not least, go to court. That is the last resort. And for most of you, it'll be small claims court. If the dispute is less than $5,000 in Connecticut, it must be in small claims court. New York is $7,500, just so you know. Every state has a threshold. It's usually between $5,000 and $10,000. Above that, you're in the official court. In Connecticut, it's the Superior Court. Okay, that's it. So you want to know what the small claims court threshold is. But it's a last resort. Court proceedings are time-consuming and they are expensive. Even if you don't hire a lawyer, even if you do it yourself, you're still going to end up spending hundreds and hundreds of hours. Do you really want to spend dozens and dozens of hours to collect a $100 debt from somebody? I don't think you really do. At some point, it's better to just write that bloody thing off and get on with your life. What is your time worth an hour? See, I'm lucky. I work in a business where I know what my hourly rate is. I know exactly what an hour of Cliff Ennico's time is worth. Most of you are not in businesses where you bill by the hour. But let me ask you, what do you think your time is worth? I know people who have taken literally hundreds of hours trying to collect a $1,000 debt. The time that they spend doing this, they are working for less than minimum wage. That makes absolutely no sense. Unless there's a compelling reason otherwise for you to be doing this, and there might be, we'll talk about that, you really have to again, revenge is a dish best served cold. Don't take this personally. Remember, you're a business person. None of us can afford to work 100 hours on a project that's only going to get us $100 in return. None of us can do that in this room. Neither can you. Okay, now let's walk through each 4 of these. Make a demand for payment. You cannot legally enforce a debt unless you have made an official demand for payment. Your invoice is not enough. You have to send a letter or some other communications. A lot of people do this via email these days, saying, hey, this is to let you know, our contract said that I was going to do this, you were going to pay me this. I sent you an invoice, it's been over 30 days, my invoice has not been paid. Please pay within 10 days or else I will have no choice but to pursue all available remedies against you in court. Love and kisses, you. Okay. Now, obviously, the order here is not fixed. Certainly, by this point, you've had at least 1 phone call with the client. You've tried to negotiate with it. But the first step is you've got to let them know, hey, you're in deep doo-doo here. This debt is now due and payable. Okay. I've written some books. I mean, I have forms of demand letter. If you float around online, you'll probably see some of the forms of the letters that I use. They're pretty public with this. It's not rocket science. Keep it short. Keep it simple. Stick to the facts. Don't get into a whole charade about you did this, you did this, you did this, you did this, you did. Don't get emotional about this. Just say, here's the situation. We had a contract. Here's a copy attached. I did the work, 10 hours. You did not complain about this. Here's the invoice I sent you. Invoice is very clear. Net 30. It's now 60 days past, and you owe me this money, with interest. A good little trick to the demand letter, if you forgot to put the interest thing in your contract up front, you can put it in now. You can say, and if I don't receive the payment within the next week, interest shall be due at X% per annum. The only thing is you can't go backwards. You can't say that interest is due from the date of the original contract. You can't do that. What you can say, if you forgot to put your interest language in the contract and you're doing it in your demand letter, it has to be from the date of the letter going forward. You can't do retroactive things, but it's better than nothing. You know, and oftentimes just the threat of interest accruing will get the debtor to start talking to you, which is what you want it to do. Have your attorney draft and send this. I mean, you can by all means send it yourself. You don't have to be a lawyer to send a demand letter, but it sends a much stronger signal when it comes from a legal letterhead. You know, then the person knows you are serious. You're moving now into pile 2 from pile 3. You know, you actually went to the trouble and the expense of hiring an attorney to do this. They know now you're serious. You're spending money here. They don't know how much. I will share with you, most attorneys will not charge you a lot of money for doing this. Most attorneys, even if they don't do litigation at all, they will do this for about maybe a half an hour of their time, something like that, which is not going to be a big bill. But just having that letter on legal letterhead sends a signal that you're serious, and again, it will prompt a response. The person is much more likely to respond to a letter on a legal letterhead than your personal stationery. So something you may want to have to consider. Okay, I say 1 hour, it's probably half an hour. These are very standard forms. All they do is they ask you, the attorney will ask you for your invoice, the contract, and they fill in the blanks in a form document. They basically do. Okay, interest shall accrue from the date of this letter at 12% per annum or the highest rate, you know, blah, blah, blah. If you had this language in your original contract, you do not have to do it in the demand letter. But if you forgot, now you have the second bite at the apple where at least going forward, you'll be able to collect interest on your overdue debt. Okay. Now let's talk about negotiation. And to be fair, I'm not saying that these things happen always in this very strict order. Very often there'll be some negotiation before you send the formal demand letter, because the formal demand letter kind of scares people sometimes. Inevitably, it arrives at the person's home, the spouse opens the letter, you know, and which of course is not a bad thing from your perspective. One of the best ways to get paid is to get the person's spouse on your side there. Get them nervous. I hate to say that, but it really is true. You know, if they open a letter saying that the spouse owes $50,000 to somebody, they didn't know about that before, that's going to be, shall we say, a very focused conversation that is going to take place, okay? And it's a conversation you kind of want to have happen, you know, and so seriously, you try to get the spouse on board your side. Things get paid a lot faster when the spouse gets ticked off. There's only really 2 ways that you can negotiate a debt. We lawyers call these things compromise and extension. Compromise means that you're writing off some of the debt. So, and I'm sure some of you have done this. Look, Joe, I realize you owe me $100, but here's the deal. Pay me the next week, I'll cut it down to 50. If you can pay me 50 within the next week, I'll write it down. That's a compromise. That's when somebody is writing off, you're writing off part of the debt if the person pays within a specific time frame. You're getting something in return. Pay me now, put me in pile 2, and pay me my money now, and I'll give you a break. That's a compromise. Extension means you're not giving them a break, but you're extending the time for payment. Look, okay, you owe me $500. I realize that's a big chunk of money for you. Can you pay me $100 per month for the next 5 months? I won't even charge you interest. That's an extension. You're giving them an extension of time to make the payment, either with or without interest, okay, depending on the amount, okay? Or some combination of the 2. You might say, well, all right, you owe me $15,000. I can't really take a big write-down on that, but here's the deal. I'll let you pay $10,000 off, $1,000 over the next 10 months, and if you make all the payments on time, I'll write off the remaining 5. That's an example of a combination, compromise, and extension. Those are really the only ways you can negotiate a debt, if you think about it. The only 3 ways that I know of to do it. If you're offering an extension, ask for, now keep in mind, now you're making a concession here. You're waiting for your money, in some cases without interest. Your original contract says you get paid by now. Now you're saying you're willing to accept payment over a period of time, but one of the first rules of negotiation is you never make what we lawyers call a gratuitous concession. You never make a concession without getting something in return. I always like to get something in return. If a client of mine is willing to be flexible, I want my client to be in a slightly stronger position. And one of the things I like to ask for, we call this a UCC lien. That's not an UC lien. It's a UCC. The UCC, if you're interested, stands for Uniform Commercial Code, because that's the statute that lets you do this. But basically, what I will sometimes do for my clients is I'll say, okay, my client is willing to settle, you know, for a payment schedule, but he wants a lien. He wants to have a lien on all the companies, all of your assets. That's like, a UCC lien is like a mortgage on personal property, not real property. That's what a UCC lien is. And you actually, you file a document, it's called a UCC-1 with the Secretary of State's office here in Connecticut, or it's usually the Secretary of State's office. So it's on public notice. It's just like a recorded mortgage. you know, this company, you know, Cliff Ennico has a lien on all assets of XYZ Enterprises, Inc. That's what it does, you know. That does something very important. If the client ever goes bankrupt, a creditor that has a lien on assets will get paid before a creditor who does not have a lien on those assets. So, you know, while the lien itself doesn't mean anything, if the person pays all the payments on time, the lien goes away. But having that lien is a very good thing to ask for because it puts you higher in the pecking order if the client goes out of business and you have to take a distribution in liquidation. Okay, so that's a good thing to ask for if you're agreeing to any kind of an extension. If the client agrees to a compromise or extension, please get this in writing. I'm not a big fan of email. I'll be very honest with you. As an attorney, I think email causes as many problems as it solves, and texting, forget about it. But here's one thing that email is actually very good for, especially if it's for smaller debts where you don't want to have like a formal agreement. You don't want to pay an attorney an hour of his time or her time to do a compromise or extension document for a $100 debt. That makes no sense. Email can be perfectly valid. You know, you email the person saying, no, our agreement is this. I'm willing to take my payment in installments, provided that, you know, you will do X, Y, and Z. And the person says, yep, that's right. That exchange of emails is a valid settlement of the dispute. Okay. And now, although I will tell you something, just to humor me, I know this is the 21st century. I know that everybody does things on social media and all, and we're all living digital lives now. But just humor me. Some of you are going to groan when I say this. Whenever you have an email communication like this, where the person is agreeing to something, print the emails out and keep them in a folder. Seriously. I know that sounds old-fashioned. You know, most of us use Gmail, Hotmail, you know, one of the cloud services, right? So we're not really worried about losing our, but let me tell you something, okay? I back up I use Gmail. That's my email survivor. I back up my Gmail emails, and I do that for two reasons. Number one, I'm an attorney, so I got to keep everything, you know, until the cows come home, until our son turns into a red dwarf. I have to have all my records. But also, too, I hate to say it, I'm too cheap to pay for the extra space. You know, so when I see myself going up over 50% of what is it, like 30 gigabytes, whatever the heck they give you, I just start backing up stuff, and then I erase things because I don't want to have to pay, because Google does. I mean, Gmail is very cheap if you stay within that 30 gigabytes, but then when you start buying additional space, it gets awfully expensive. So I'm just too cheap to pay for the extra fee. I'll admit that. I'm a lawyer. I'm human, you know, after all, I think. But seriously, the trouble, there are several utilities, and they're free, that can help you back up Gmails. The problem is, they'll back up the emails, and they'll do a job of the emails themselves, but they don't back up the headers or the folders into which you put them. They only do it in strict chronological order. So when you back up your Gmail onto a CD, all it says is the time of each email. The good news is everything's there. If you open each file, all the text is there, the attachments are there, everything is there, but the headers are not there, so you can't tell which one was the Cliff Ennico file, which one was, you know, you have to actually go through each one of the 10,000 emails on that CD, that backup CD, to find the one you're looking for. So if you get nothing else out of this, whenever you have an important email exchange with somebody, something that you think is a contract, print the bloody thing out. Keep it in a file so you can always lay your hand on it within 5 minutes. And then, to the extent you can, stop working, deny service. Stop digging the hole. The hole is 3 feet deep, it's not going to go to 5. Okay? I got a 3-foot hole, I can deal with a 3-foot hole, I cannot deal with a 5-foot hole, so I'm stopping digging. Okay. Now, mediation, arbitration, there's a basic difference between the two, but that really doesn't matter. Mediation is a brokered agreement. Mediation is not a court case. Mediation is a discussion. You know, you can do it yourself, or you can hire someone like me. A lot of lawyers act as mediators, especially in divorce cases. 90% of the divorce lawyers in Fairfield County are mediators. They don't go to court at all. They just, you know, try to beat the two sides apart. And I'm sorry, you may have had other experience, but that's perfectly okay. You're probably right. But you know, most divorce lawyers here in Fairfield County, Connecticut, are mediators. This, I think, is true everywhere. Basically, what happens is they sit in a room. The mediator kind of beats up on one person, kind of softens them up, and then goes to the other side and tries to beat them up. And they try to get them to meet in the middle and shake hands. And then if they do, it's documented, and that's the settlement. Okay? but it's not a court case. The mediator does not have the ability to say you're right and she's wrong, or vice versa. Okay, the mediator is there to try to get to yes, to get to an agreement, and it can take a long time. And of course, if you have a mediator like me, it's going to cost you some money. You're not going to use a third-party mediator for a $100 dispute. That's not going to happen. Okay, but that's what mediation is. Arbitration is a mini court case. Have you ever watched Judge Judy or any of the TV judges? That's what an arbitration is all about. It's a very informal court case. There's no rules of evidence. You don't have to, there's not a lot of protocol. It's just the two people sitting down presenting their evidence, and the arbitrator does get to make a decision. He can say, you're right and you're wrong. You have to pay and you don't. That's the difference between mediation and arbitration. I mean, if you are interested, there are some very good online mediation programs. Is anybody here sell on eBay at all? Amazon? PayPal actually has a very good mediation service. I've been very impressed with PayPal mediation. They actually do listen to you, and they really do try to they don't always take one side or another, although I will tell you that if it does come down to like a real 50-50 thing, they always rule for the buyer. That's just the way they are. And I hate to say it, but a court would probably do the same thing as well. The idea is that if this case is so close that even a learned judge cannot figure out the answer, the seller is in a better position to take the loss than the buyer is. I hate to say it, but that's the rationale behind that. It has nothing to do with the law. It's just simply this person can take the loss and better than that person can, especially if it's a consumer, an individual buyer. There's also, if you have anybody here own a franchise, but there's actually a very good dispute resolution system between franchisors and franchisees. So you buy a franchise, the thing doesn't work out. 3 years later, you think the franchise is a fraud. Rather than suing in court, you can actually go to this service and they can actually try to get you a negotiated settlement. It's actually quite good because they focus specifically on franchise situations. It only works though if both parties agree. You know, if you say to the other side, I want to mediate, and the other person doesn't respond, well, you haven't really gotten anywhere. Unless, of course, there's a clause in the contract that says, we shall mediate disputes for a period of at least 90 days before we bring suit. That is a clause that a court would enforce. Now, keep in mind that if that clause is in your contract, you must honor it. So if there's a mediation clause in your contract and a problem occurs, you can't just go running to small claims court. You won't be able to do that. You said in your contract that you would mediate, so you've got to go through the mediation period before you can sue in small claims court. And of course, what's the big mistake that people make when they do mediation clauses? Anybody want to guess?
They leave it open at the time.
They leave it open as to time. You're right. You're good. You got it. You're exactly right. There's no time limit. It just says we'll mediate. It doesn't say for how long. You can mediate for years. There are mediations, especially like labor contracts, that go on for years and years and years. They don't ever get resolved. And in the meantime, you can't enforce your remedies. You know, although the good news is the statute of limitations tolls during that period. You don't have to worry about the statute of limitations expiring. You know, if the mediation doesn't work out, eventually you can bring your lawsuit in small claims court, but by then you're dead. You're 98 years old, you're in a nursing home. I mean, who wants to be bringing suits in that case? Okay, nobody does. Okay. Also keep in mind, arbitration especially can cost as much as litigation. Anybody who tells you that arbitration is cheaper than litigation is lying. Arbitrations can take just as much time as litigation can. I try to stay away from arbitration clauses except in areas like construction contracts where they're customary. You know, people expect them, but other than that, I try to avoid arbitration. Arbitration doesn't really, you're not really saving anything there. I prefer mediation, or I call it, I actually use a clause that says basically that the two sides will meet and try to resolve the dispute amicably, and if that doesn't work out, they will appoint X, usually the company's accountant, as a mediator to resolve for a period not to exceed 90 days. That's kind of how I set my clauses up. I'm not saying that's the perfect way to do it. There's no such thing as a perfect solution here, but I'll be happy to share with you what I myself do. Okay, now we're in small claims court. Okay, this is the last resort. I'm assuming the claim is less than $5,000. It usually will be. Where do you sue? Always where the client is located, not where you are located, especially if the client, the person who owes you money, is in another state. You have to go where they are. Okay? Why? And now, of course, unless, of course, there's a clause in your contract, we call it a choice of law clause, that says, in the event of a dispute, the suit will be brought here in Fairfield County. Okay, but I'm assuming that most of you don't put that kind of language in your clause. That's mostly for bigger contracts. You know, small contracts, especially online contracts, don't usually have that kind of stuff in there. Okay, it's always a good idea to go to where they are, and that's for two reasons. Number one, it scares the hell out of them, first of all. You know, the fact that you have taken the time to come and sue him on his home turf, where you might be able to get a lien on his bank account or his house or the personal assets, that will get his attention. That'll get you into pile 2 in a hurry, okay? That means you're to be taken seriously, because normal people don't do that. You've identified yourself as a crazy creditor, and that is a good thing, because that gets you into pile 2. Crazy people, crazy creditors are always in pile 2, and that's a good place to be. Also, too, and this is more of a legal answer, there's a clause in the Constitution. A lot of people don't know about it. It's called the Full Faith and Dealing Clause of the Constitution. It's in Article 4 somewhere. It says that if you litigate in State A and you get a judgment, and then they try to enforce the judgment in State B must, under the Constitution, honor that judgment in State A. Okay, you cannot go and say, well, okay, now we've litigated this in California, now we're going to do the whole thing over again in Connecticut and cost you $100 millions. You can't do that. That clause of the Constitution prohibits that. But there's a big loophole, and the loophole is default judgments. What happens if you sue this person? Let's say somebody in California owes you money. You sue them here in Connecticut, and they just don't show up. They don't return the phone calls. They don't file the papers, whatever. Okay, well, the good news is you get what's called a default judgment. The court says, well, other side's not here. Boom, judgment for you. Good news. Now go to California and try to enforce that. The California courts, and most courts, by the way, will not enforce a default judgment in another state. The theory is somebody who lives in their state and who votes, that's important, especially where judges are elected, which is the case in many states. Somebody in my state, the judge is going to look at this and say, somebody in my state did not get his or her day in court because he was forced to go to Connecticut, which is the other side of the world. You know, nope, I'm not going to enforce that default judgment. You have to bring the whole thing over again here in California, under California law with California lawyers. That's what will happen. So you're better off beginning the suit there anyway, because the default judgment here is not going to do anything. And whenever I hear that a client's being sued in a foreign state, the first thing I tell them is don't show up. Don't show up. Take the default judgment, let them come here. Let this person spend money on a Connecticut lawyer, you know, come to Connecticut, staying in a Connecticut hotel, which is very expensive. Let him do all that if he really is serious about enforcing this claim. Okay. Do I really have to go through that? Well, yeah, it also sends the signal that you really be business. Oh, and the other thing is, and this is that blurry thing at the bottom, I apologize again, the travel, and if you do go out, because at some point there will be a court hearing, you have to go out to California, the travel and lodging expenses are 100% deductible on your taxes. It's enforcing and collecting a debt is an ordinary and necessary business expense for tax purposes. You can always deduct that. The meals, though, are only 50% deductible, but the travel and lodging expenses are 100% deductible under current law. Why not get a little bit of benefit from this from Uncle Sam? I understand that Santa Monica is very nice this time of year, by the way. You can bring the kids, you know, you can do stuff like that. Anyway. I actually have a client who does that. Whenever he has somebody in another state, he says, you know, I've always wanted to visit Ames, Iowa. It's a beautiful technique. You can use that yourself. I always wanted to, no, I'm not going to do this here. I'm going to come out to Iowa. I've always wanted to see Iowa this time of year. You do not want to see Iowa in April. If you have allergies here, don't go to Iowa in April, okay, or May. That's the thing. Not to knock Iowans, but, you know, there's a lot of grass and pollen out there, much more than there is here. Okay, so now you're going into small claims court. First of all, get the forms. The good news, I like this site, uslegalforms.com, great site. They have a whole set, they have all the small business call claims courts forms of all 50 states, and they keep them up to date actually pretty well. You have to pay like $10, $15 for the download, but it's not a bad deal. Or you can simply call the court. If you call the court office, they'll send them for free. It'll take 3 weeks, of course, because they snail mail them, but you'll get them for free. But if you don't want to wait that long, U.S. Legal Forms is pretty good. There are other legal forms I don't like a lot. I mean, I would not rely on a form of real estate document, for example, that I got off U.S. Legal Forms, even if it says it's Connecticut specific, but the small claim stuff is pretty good. They're all printed forms anyway. Watch lots of television, and I'm serious about this. Okay, by the way, that website is unfortunately a little, it's out of date. They took off the TV. It's now just called judgeshows.com, so you might want to make a note of this. This is basically a fan site for all of the Judge Judy type shows, you know, the judges shows. What's the name? Joe Brown, Mills Lane, there's a whole bunch, 18 million judges who think they know what they're doing, and this is where you can find out about all their shows. Seriously, watch a lot of TV, because that's what a small claims proceeding is all about. It's exactly Judge Judy. You go there, you know, the judge listens to your side, he listens to the other side, and he basically decides who's telling the truth and who's telling a bunch of crap. That's basically what it is. There's not a whole lot of legal analysis here. Basically, say, okay, this person's telling the truth, that person's full of it. Okay, judgment for this person, and you know, and next case. They don't even have to explain why they do it. Often, you know, it's just that proceeding. And I will tell you, victory in small claims court always goes to the person who is better prepared. If you go in with better preparation, you will almost certainly win your case. Almost certainly win your case. Have your documentation in order. Here's the signed contract. Here's the invoice. Here's the demand letter we sent. Here's copies of 10 emails where I begged this person to respond. You know, have all your ducks in order that the judge can see. And now the other person's got to, he's the one who's got to climb pork chop hill here. And he's probably not going to be able to do it. You know, it's like Judge Judy, right? When one side is better prepared than the others, who always wins in Judge Judy? The person who's better prepared. Okay, who can answer? Judge Judy says, I want to see this document. The document comes right off the bat. That is the best thing you can do if you're ever on Judge Judy's show. Always have that stuff ready. She asks for something, you give it right to her. Okay? Prepare, prepare, prepare. Be on time. Keep it simple. Don't, you know, just the facts. This is not a legal hearing with rules of evidence and all that kind of stuff. Keep it simple. Just tell your story. You know, stay away from lawyers is what that says. The last bullet. Don't, if the judge thinks that you've been coached by a lawyer, they really look negatively on that. They do. So, for example, if you don't go around in your life saying things like, may it please the court, do not do it in a small claims hearing. No, really. You know, I mean, I might be able to get away with that, you know, because I'm a lawyer and that's just a force of habit, you know. But don't say stuff like that, because then they know, oh, geez, he's been talking to a lawyer. That kind of evens the scales a little bit. The judge likes you. They think you got a solid case. But now they think that you have an advantage over this other person who clearly is an idiot who's representing themselves. And they don't like that. They don't like to see uneven battles, just like we don't. You know, they're human too. They don't like to see an unequal fight. So just don't sound like a lawyer, you know, just go in and just be yourself. You know, if you're a contractor, talk like a contractor. You know, that'll do you much better than sounding like a lawyer. And stay away from lawyers. Seriously, I mean, you know, I get clients that want me to coach them, and I say, I'm not going to do it. You know, I'll ask you some questions. Do you have this? Do you have this? Do you have this? Okay, you don't have that. Make sure you have that. I wouldn't go before Judge so-and-so without that. But I'm not gonna, you know, try to give you too much information, because you're going to start sounding like me. And believe me, the judges do not like me. So. No, actually, they don't know me from Adam, actually. I don't really do a lot of litigation, so I can't really say that. Okay, now, here's the trick. So you go there, you go to Judge Judy or Judge whoever, you get your judgment, victory is yours. Now you got to enforce the bloody thing. Okay, and this is where our system here in Connecticut does not do a very good job. The first step is easy. You go to the court clerk and you ask for something called a writ of execution. They always give it to you. It may take a few days for them to put it together, but you're entitled to that, and that's what you paid the fee for, is to get that. That basically entitles you to go against the person's wages, real estate, property, bank account, everything. You can make this person's, it's a license to make that person's life totally miserable until you are paid in full. That's what the writ of execution is all about. In most states, you could hand that writ of execution to the sheriff, and the county sheriff, and they will do all the legwork for you. They'll, you know, bang on the door, they'll serve it on the person, you know, wake up the kids at 3 o'clock in the morning, you know, they'll do all that nasty stuff. Here in Connecticut, though, we have budget issues. So the sheriff's office, if you take a writ of execution to the sheriff's office, they'll be very nice. They'll say, we'll do this when we have a moment, when we have an officer in the area, and nothing ever happens. Okay, you're the one who has to do the legwork. You got to go to the banks. You got to know where their bank is. Of course, if you've been getting checks from them, you know where the bank, which bank they use. You're going to have to go there, make absolutely certain that you've got the right person. There are a lot of people out there named Michael Smith, and you might be surprised. There are actually more than a few people called with names like Mohammed O'Reilly. Okay, you got to be careful. Make sure you have the right person. Because the bank officer is going to say, well, we got 10 Michael Smiths, which one is yours? Well, the one who resides at, and just make sure you got the right person. Because, and I'll tell you, I'll scare you a little bit, if you file and garnish the wages of somebody who's not the right person, that is libel or slander. That's defamation of character. And they can come after you with the full force of the law. They will not be limited to the amount of the small claim. They could sue you for $1 million. You know, if my account was frozen because you thought I was some other Cliff Ennico and I couldn't pay my people, my suppliers, I got clients screaming at me because I can't file their documents, I can't write the checks to the Secretary of State's office, I'm going to come after you with every gun blazing that I have, and I will not apologize for that. You know, my reputation is everything. So if you do decide to enforce it yourself, just make sure you got the right person. If it's a name like Cliff Ennico, you're probably okay. It'll be pretty easy to track me down. You might. This is a very new thing. A number of websites have sprung up in the last couple of years that offer to buy your small claims judgment for a discount. They'll usually give you 50 cents on the dollar for it, 40 to 50%. You sell it to them, or sometimes you put it up, you post it, and somebody else will buy it, okay? And then they try to collect the whole thing, okay? Ask yourself, who would do such a thing for a small claims judgment? Well, you might be surprised. Some lawyers do it. They do it. Young lawyers sometimes will do it to get experience, believe it or not. They didn't serve an apprenticeship, so some will do it because it's a nice, safe way for them to maybe get some experience in court, get themselves known to the judges. I mean, I really don't know who else would be interested in doing this. But there's a question about the legality of these websites. There's a very old-fashioned word. It's called champerty. It dates back to the Elizabethan Tudor times in England that says that it is illegal to take a financial interest in a lawsuit. So for example, if you have a claim against somebody that you can't afford to bring, and I come knocking on your door and say, hey, you know what, I think you got a great claim here. Tell you what, you bring this claim, I'll pay your legal fees, and if there's a settlement, we share it 50-50. That, believe it or not, is illegal in just about every state. It's called champerty, C-H-A-M-P-E-R-T-Y, if you want to look it up. It is not encouraged. Now, there are some exceptions to that. You know, obviously, bail bondsmen and people like that are not committing champerty when they do their jobs, but you got to watch out for that. I'm not sure that some of these sites are legal. Having said that, the one that I'm aware of is one called judgmentmarketplace.com. Take a look. You might be able to get a few cents for your judgment without having to do anything. Okay, the slide you've all been waiting for. Okay, despite everything I've told you in this presentation, you are taking this debt thing personally. You want to beat up on this person. You want to make this person's life miserable. You want to turn it to Tony Soprano or something worse, okay? How do you do it legally? All right, well, you do have some options. Better Business Bureau, you know, give them a whack on the wrist. I mean, people do check the Better Business Bureau, especially construction contractors. People will check, when people hire construction contractors, they will go to the Better Business Bureau and look at these. Frankly, they don't do anything. Don't expect them to do anything, but at least you can give them the person a black eye. You know, and in the Better Business Bureau records. That you can do. Okay, be careful. Again, remember, whenever you're trying to enforce a debt, if you don't do it 100% right, you are opening yourself up to a claim of defamation, what we call libel, slander, or something worse. And there's no cap on those kind of damages. If you libel somebody, they can come after you for punitive damages, mental distress. It's a mess. Okay, they're not limited to the amount that they owe you. I'll tell you a scary story in a minute. Okay, the better thing, what people do, they flame the debtor on websites, blogs, Yelp.com. There's one called Avvo, A-V-V-O, which is for professionals. There's a bunch of sites where all you can do, idiots can basically go on and say anything nasty that they want about somebody else. Okay? Okay. If you are tempted to do this, here is the trick. Try to keep as opinionated as possible. Now, that sounds weird, okay? I just told you not to get emotional, okay? But here's the trick. Opinions can never be, you can never be sued for libel or slander because of an opinion that you express. Cliff Ennico wasn't a great lawyer. I had a really bad experience with him. I don't like that. I'm not going to like that review at all. I'll try to do everything I can to get that thing knocked off. But you know what? I cannot sue you for libel for that. That's not what libel is all about. You're entitled to your opinion. The First Amendment says you are entitled to your opinion. You can publish your opinion and tell the world if you had a bad experience with somebody. Okay, but here's the trick. If you make a factual statement about me that is wrong, that's when I can come after you for libel. So Cliff Ennico, I had this rotten experience with him. He's a terrible lawyer, and also, too, I understand he's been sued 36 times for malpractice in the last year. I will tell you that I have not been sued for malpractice once in 35 years. If that statement appears ever online next to my name, I am coming after you with guns blazing, and I will take away everything you own. Okay? I will not stop at whatever the amount you owe me is. Okay? So be very careful about stuff like that. It's a factual statement that is incorrect and designed to injure somebody's reputation. That's what libel and slander is all about. An opinion is not libel or slander. So if you're going to go on Yelp, just say, I had a bad experience with this person. I really couldn't recommend him in good faith to anybody. And then shut up. No, don't go into, unless, of course, you can back it up. If you have proof, If everything you say is 100% accurate, then go for it. Truth is always a defense. If someone sues you for libel, and you can show that everything that you said was 100% true, you will win that case, but it will not prevent you from going into court. They will sue you anyway. You're going to have to, it's going to take years of your life and tens of thousands, maybe hundreds of thousands of dollars of your hard-earned money to get that judgment in your favor, even if you can prove that everything was 100% truthful. Libel cases are very easy to start. They're very hard to finish. So be careful. I mean, even if you think you're 100% on the right side, on the side of the angels, be very careful before you flame somebody online. Also, best to wait until the small claims judgment issues. Before I was a lawyer, I was a small-town newspaper reporter. I used to do the crime beat for the Yonkers, New York daily newspaper. I'm happy to share you that. It was called the Herald Statesman. I was their crime reporter. Right? And hardly a month would go by that I didn't get a press release in the mail from someone saying, court rules against local business. Okay? And there it was, so-and-so had sued for $5,000 in New York Small Claims Court and had won. And there was a copy of the judgment attached. Wait, they wanted me to put it in the paper. And of course I would put it in the paper because, hey, when you write for a small-town newspaper, anything that comes in like that, you put it in because you got to fill space, But my advice to you is if you're going to do stuff like that, make sure you attach the judgment. Do not do this until you actually have a judgment and then attach the judgment to the press release so the reporter can actually see what was actually said. Because sometimes judges will issue opinions that say, yes, but. And if you don't put that but part in when you flame the person, that could open you up to a charge of libel. So if you're going to do this, if you really want to, if you were injured by a local business and you want to give them a bad rep, and you want to send a PR to the Norwalk Hour or the Connecticut Post or one of these other papers, wait till you get a judgment and then attach the judgment so that there's no dispute about what actually happened. That'll be my advice on that. And then, now that last one, I know you can't read it, but that's okay because this is one of the best things I talk about. I probably shouldn't tell you this. Okay, I'm going to share with you some secrets of the ninja masters. Okay. There is something you can do to a debtor that will really, utterly, truly blow their minds. It's one of the most creative examples of going medieval or going postal that I know of. My advice to you would be, do not consider doing this to someone unless, number one, you never want to do business with this person again, ever, world without end, amen. And two, the amount in question is over $600. The amount has to be over $600. I'll explain why in a minute. Okay, I have a client who does this. Okay, here's what happens. He has someone who owes him some money. It's over $600. It has to be over $600. Okay, he knows the person's never going to pay, and he really hates this person. He wants to make a statement. He doesn't just want to write it off on his taxes. He really thinks this person did something immoral or unethical, and he wants to hurt this person. He wants to give this person a black eye legally. Here's what this person does. He forgives the debt. He sends the person a letter by certified mail saying, I realize, your business owes me $650. This is just to let you know, I realize you don't have a whole lot of assets here, so as a gesture of good faith, and in light of our future business relationship, there will not be any after you do this, I am forgiving the debt in its entirety. Make sure you use that word. Here's how much you owe me. I am forgiving the debt in its entirety. You send the letter by certified mail or some other way where you can get proof that they received it. Okay? Why would you do this? Well, the game's not over. Wait, and now you're going to see why it's over $600. Wait, then what you do, you take a copy of that letter, you put it in your file, you wait until January, and then you send the person a 1099 for the full amount of the debt. Why? How can you do that? Because when you forgive a debt, that is income to the debtor. They have to report that on their income taxes and pay taxes on the amount of that forgiveness. That's why you send a certified letter, because you have to be able to prove. And a copy of that, when you send a copy of that to the debtor, a copy goes to the IRS and the DRS here in Connecticut, the state tax authority. Now, of course, that doesn't put any money in your pocket, okay? But it means that he now has a problem with the IRS because he didn't pay your debt. I mean, is that, no, seriously, these are secrets of the ninja masters here, okay? You don't do this unless, first of all, and that's why it has to be at least $600, because you know you can't send a 1099 to someone unless it's the amount in question is more than $600, okay? That's why it has to be by that. You don't do this unless you never want to hear from this person again, because this person will be bloody ticked off when you do this, okay? All right, that's the one thing. So what that thing says, debt forgiveness equals income. That's what that thing said. Okay, forgiveness of indebtedness. Forgive the debt. You won't get it back, but you can really send a message that that person will never forget if you really think that that person was playing around with you. Okay, we're almost done. Using a collection agency. Okay, some people want to know about this. Should you use a collection agency? Well, there's two ways of thinking here. They are usually unemotional. If you're the kind of person that has trouble serving your revenge cold, they're in the business. This is just a business thing for them. They don't really care. So it takes the emotion out of it. That's one advantage of using a collection agency. The second thing, they are usually a little bit more aggressive than you want to be. I mean, let's face it, when you think of collection agency, what do you think of? People with tattoos, ex-longshoremen, you know, people who are just released from prison, who can't get jobs anywhere else. I mean, that's the people that these people hire, and they're pretty brutal. Now, but you have to think, they cost money. They take a percentage of everything they collect, you know, and sometimes it's pretty hefty. And then here's the biggest reason why. They're only supposed to collect undisputed debts. So if you send a demand letter and the person doesn't respond, you are then entitled to hire a collection agency. If you send a demand letter and the person comes back and says, no, that's not true at all, I don't owe you this money, you did a crappy job, my bathroom's falling apart because of the poor work that you did, that you cannot hire a collection agency for that. That has to go to court, small claims or otherwise. That has to, by law. You know, the minute that a collection agency hears that there's a bona fide dispute, they stop their collection agencies. They are required to do that by federal law. They have to stop their collection agencies. They don't have a choice. So you only do this with undisputed debts, okay? My law book publishers do this all the time. You know, every once in a while, you know, when I buy law books, you have to buy the updates, the subscriptions, and they come automatically, right? If they send that subscription out and the bill is net 30, and for some reason they don't get their money within 60 days, on day 61, the lawyer gets a call from the collection agency. They have like an automatic relationship with these collection agencies because they know you sent the thing out, you didn't return it. 60 days was more than enough time to return it if you didn't want it, so you're stuck with this. You're stuck with this thing you don't want. I hate it, but it's true. By the way, Yellow Pages here. How many people have a Yellow Pages ad? Good. Don't do it. Because they are the most ruthless people in the world when it comes to collecting debts. Because you know why? Because when you sign up for a Yellow Pages ad in your contract, there's an automatic renewal clause. It automatically renews year to year, and they don't tell you always. It's in the fine print, but it's usually a very funky date, like 105 days before the end of the then current term. Who knows what that date is? You don't know what that date is. Unless you have a calendar right in front of you, you can't calculate that. So as a result, you end up automatically subscribing for multiple years, and they're very hard to stop. Once they know, once that date has passed, they see that as a collection issue. Yellow Pages are absolutely the worst. I tell people, unless there's an absolutely positive reason for you to use Yellow Pages, do not do it. Okay, here's some things you cannot do to collect overdue debts, especially from a consumer, where the debtor is an individual. In business, you can get away with a lot more. But there's this federal statute, it's called the Federal Fair Debt Collection Practices Act, and it has a whole bunch of rules. If you Google this phrase online, there are a lot of law firms have written articles about this. So for example, you cannot call before 7 a.m. or after 10 p.m. You cannot call on Sundays. You cannot say you're a government employee. You can't say you're from the IRS. You cannot say that you are a lawyer, unless of course you are one. You cannot threaten your client with jail or criminal penalty. You cannot say, I will put you in jail. I'm going to have the cops come after you. I'm going to put out a warrant for your arrest. We do not put people in jail just because they owe you money. We did away with the debtors' prisons back in the 1700s in this country. You cannot put someone in jail just because they owe you money. Now, if there was other things like fraud or something like that, you might be able to put them in jail for that. But you can't just put someone in jail. You know, Charles Dickens wrote, novels. Remember Mr. Micawber? Who ends up in a debtor's prison, and he finally has to go to Australia, because he can't pay all his debts. He's the sweetest guy in the world. W.C. Fields played him in the movie back in the 1930s. That's how good he was. I mean, we don't do that in this country anymore. This is a democracy, okay? And I will tell you this, by the way, be very careful. Basically, you can't misrepresent or embellish. That's what that last thing says. You can't misrepresent or embellish, and you got to be careful. I'll share this story with you. It's a real horror story, but a few years ago, I had a client who really did owe a lot of people a lot of money. He ended up filing bankruptcy. He couldn't deal with it. And one night, when he and his wife were out to dinner, His 13-year-old daughter was babysitting the 2 younger kids, and the phone rang. It was about 10 o'clock on a Saturday night. She picked it up, and this guy, whoever he was, started railing and ranting and using 4-letter words, saying he was going to put her father, he asked who she was. She told him. He said he was going to put her father in jail for doing this. He said, well, you better save up your money, honey, because your father's going to jail. He owes me a ton of money, and I am going to come after him. I'm going to take your house away from. This is a 13-year-old girl, all right? What would you have done if that was your daughter? Well, the bottom line is he actually sued this guy, and he won, believe it or not, for violation of the Fair Debt Collection Practices Act. You've got to be again, keep your emotions at bay. Revenge is a dish best served cold. The minute you let your emotions take over, you risk doing something really stupid like that will open up a horrible can of worms, worse than the debt. Almost done. Okay. If the debtor files bankruptcy, okay, first of all, the minute you know that a debtor has filed for bankruptcy, you must stop all your collection activities. Must, absolute. There's something called the automatic stay that descends at the moment the bankruptcy petition is filed, and you cannot continue any collection activities, repo activities, whatever it is you may be doing. You have to file a claim in the bankruptcy court proceeding. Most attorneys who do this, that's a very high estimate, to be honest with you. Most attorneys will charge about an hour, hour and a half of their time. So maybe $200-300 to file a claim in bankruptcy. If you have a secured claim, remember that UCC lien that we talked about? You are at the very top of the pile. The secured claims get paid before anybody else does. That's what that UCC lien gets you. Okay, so you want to consider doing it, especially if you know the client's having trouble paying you. And then when you file your claim, you then wait. If there are 2 kinds of bankruptcies. There's reorganizations and liquidations. If we're dealing with a reorganization where the client eventually comes out of bankruptcy and resumes business, okay, you will be asked to restructure the debt. The bankruptcy trustee, who's usually the debtor's lawyer, will call you and will make a very powerful suggestion that you restructure the debt, and he'll even suggest what the restructuring terms should be. If the debtor liquidates, however, and goes out of business, then what happens is the trustee collects all the money, all the assets that the debtor has, and all the creditors get X cents on the dollar. You might get 10 cents on the dollar, 30 cents on the dollar, something like that. That's the best, and then that's it. Then that debtor becomes discharged in bankruptcy, which means that they can now go up and run up all kinds of new debts and start all over again, right? How many of you here know of someone who did this back in the 80s and wrote off their student loan debt? They filed for bankruptcy right after, like literally, in some cases, less than a year after they came out of college. They filed for bankruptcy and got a discharge specifically to get rid of their student loan debt, because they figured that by the time the 7-year period had passed, they'd still be a young person. You know, let's face it, at 27 years old, you don't tend to go back and look at what they did at 20 usually. You just don't. So that was a game. The bankruptcy laws were changed in the 1990s, so you can't do that as flagrantly now, but a lot of people still do it. Again, know when to cut your losses, okay? Managing your emotions is the key to successful debt collection. Sometimes, I mean, there are times when you want to go to great lengths to pursue a small debt because it gives you a reputation as a mean motor scooter and a bad go-getter. Remember that alley-oop from the 1950s, the doo-wop song, right? But seriously, there are times when it pays to get a reputation as a real SOB. You know, I know attorneys in this town who will tell you, you don't mess with this realty company because they are a bunch of SOBs. They will sue over everything. That's a good reputation to have if you want to deter problem debts. You want to get the reputation of the SOB who'll go to court over anything just because you find it fun. You know, and that might be a good thing. That's one reason why you might want to do it, just to send the signal that you're not somebody to be trifled with. But most small debts aren't worth the effort. Time is money. And remember, you can always write worthless debts off on your taxes as long as you have made a reasonable effort to collect them. The IRS allows this. Every business that I know of has a bad debt allowance. Usually it's 2 to 3% sometimes of their total volume of business, their total gross sales. And the IRS, as long as the IRS can be comforted, if they ever audit you, they want to see that you made an effort. So keep those demand letters that you send out to people. But as long as you made a reasonable effort to collect, they will let you deduct those bad debts on your taxes as an ordinary and necessary business expense, as a write-off. But be careful. The audit guide, the IRS audit guide has parameters. If you ever do get a field audit from the IRS, they actually kind of know, they keep statistics on these things. They know that an antiques business typically has bad debts of between 1 and 2% a year, so that if you claim 7%, you know, they're going to want to know what's going on there, or do you just not know what you're doing, you know, that kind of thing. Be very careful. You might want to have a tax lawyer take a look at the IRS field guide and look at your business and say, what's a reasonable bad debt reserve for our kind of business? You know, because you don't want to be too far out of those boxes as much as possible. Okay. Basically, here's some books. I mean, the first book is one that I've written. It's my eBay sellers. This is specifically for people who sell on eBay, Amazon, and online retail. But there's a lot of good information anywhere there about how to deal with bad debts. Nolo Press is a very good publisher. They're in California. They specialize in self-help legal books. And some of them, the books are kind of uneven, but the ones on debt collection are pretty good, actually. They talk a lot more about the Fair Debt Collection Practices Act. They have forms from some of the states and that kind of thing. It's pretty good. Small Claims Court, Step by Step, Ted Rothstein and Isaac Drucker is kind of a classic. It's been around for about 30 years. And if you really want to become a small claims court king or queen, this is the book you want to invest in, because it teaches you, you know, if you're the kind of person who's going to be in small claims court at least 5-6 times a year, this is the book you probably want to invest in. And then I just love this book. Michelle Dunn, I actually know her personally. I met her on the eBay circuit. Become the Squeaky Wheel. Get into pile 2. Okay? If you do not get into pile 2, if you're not in pile 1, if you're not somebody that the business utterly depends on for success, you got to get into pile 2. You got to make yourself so obnoxious, unreasonable. Seriously, if you have any acting ability, I mean, there's this one attorney I know in Fairfield County. He's the nicest, sweetest person. Our wives socialize together. We go out to dinner at least 2 or 3 times a year. If I introduced him to you, he's the nicest, sweetest guy you ever wanted to know. But you never want to be near this person when he's on a collection call, because he comes on like a total maniac. He uses 4-letter words. He yells. He screams. He does everything. You know, he uses foul language. He says he has a thick Brooklyn accent, so he sounds like a gangster. He does when he does this. And he's very effective. He gets a lot of money for his clients, because the client says to himself, if I were that debtor's lawyer, I'd say, you know what? This guy's a notorious jerk. He's a flaming you-know-what. Just how much do you owe him? $450. Find the money. Pay this guy off. Hit up your credit cards. Just get this jerk off your back. You know, it's not worth paying me to have to call this guy and listen to his tirades for a half an hour. Then you're paying your debt twice over. That's what you want the debtor's attorney to do, is to put you into pile 2. So get in touch with your inner witch or your inner bastard. Is probably the best advice that I can ever give you. Let's face it, this person is not nice. This person owes you money. This person is taking food out of your pocket, food out of your children's mouths. Why should you be nice to that person? I don't know about you. I haven't a clue why you should be nice. Of course, I'm a lawyer. Nobody pays me to be nice anyway. But I think if you can get in touch, you'll find it's amazing how your performance on overdue receivables will improve if you start getting a little tougher and a little nastier about how you go about collecting them. Sending the message that you have zero tolerance for overdue debts is one of the best things that you can possibly do to avoid them happening in the future. Okay, that's it. That's all I have to say for my prepared remarks. This is my best. I know you have a question. You've been dying to ask it. Go ahead.
Just a comment. The judicial website in Connecticut, the jud.ct.gov, is a very good one to get the forms as well. You can go on there and use it.
Yeah, no. And I apologize. Because we're doing the video here, I didn't want to be too state specific, but you're absolutely. It's www.jud for Judiciary Department.ct.gov. That's where you can get all the small claims forms here in Connecticut without having to pay any money for them, because they're absolutely free. Yeah, that's right. But if you're in another state, for example, somebody in California owes you money, you got to find out California. What I would do, Google California Small Claims Court. You probably have to go to the county because in California, each county has its own little rules. So the forms from county to county don't always look the same. So you got to get to that specific. I mean, there's a couple of tricks you have to do here, but that's why I say the U.S. Legal Forms site is very good, because you can be very specific. Medina County, California, and it will give you exactly the forms that you need. And all right, for $10-15, it's probably worth that. Okay, sir, I know you have a lot of questions.
No, I just think when you went, that woman, that 13-year-old girl went to court.
Doesn't that hit home?
With her father, you know, how could she prove that's what he said?
Well, they can't prove what she said. There'd be no way of proving what she said, what the creditor said, but you can subpoena the phone records to show that a phone call came from that number at that time. And then it was approximately so many minutes long. And then, well, let's put it this way. If I were the judge listening to that, I would really want to know, you know, I really have some very focused questions for that creditor. Now, always make sure that you're talking to the person, you know, I mean, You can talk to spouses and relatives, but be very careful what you say. When it's me, I usually, and I know I'm speaking with the person's spouse and not them, I will say something like, well, I'm attorney Clifford Ennico from Fairfield, Connecticut. One of my clients has a serious business dispute with your husband, and frankly, we're looking to find out who his attorney is so that I can speak directly to that person. The minute the spouse hears that there's going to be a big legal bill in the house, the conversation will take place that I needed to. So I have to be very careful. I have to be, as a lawyer, I have other rules that I have to do. I cannot negotiate directly, for example, with that person. I can only negotiate with their lawyer. I cannot negotiate unless that person specifically waives the right of counsel in writing, which they never do. So seriously, and by the way, if an attorney ever does that to you, if someone really is an attorney tries to negotiate with you, you can throw that back at them and say, well, wait a minute, isn't there a rule of ethics that say you can't do this, you have to speak to my attorney? It's absolutely true. And they will, if they're smart, they'll back off when they see that you know what you're doing, by the way. Attorneys cannot do that. 90% of the time, though, when they do it, it's really not an attorney anyway. They're saying that they're an attorney, that kind of thing. That's like people who have a PhD saying that they're doctor, that kind of thing. Yes, ma'am.
Any suggestions for credit card companies when you're a small business that provide services?
Any questions about credit card companies doing better? Try not to do it. Yeah, chargebacks. The whole issue. Chargebacks are the bane of taking credit card as payment. I hate these things. Somebody pays by credit card. You render your services, you sell them whatever, they take possession, they don't do whatever, and then within 90 days, they can totally reverse the charge, and now you're stuck. And now you're fighting with their credit card company. Okay. Piece of advice number one. You should always have merchant accounts with all the major credit card companies. American Express, Visa, MasterCard, Discover. Why? Because even if you don't plan to take them, have the merchant accounts. Why? Because that way, if someone who uses that credit card charges back, you are seen as their customer. You see, whenever a credit card company has a fight between one of their customers and someone who isn't, guess who wins? Almost always. So you want to have the accounts so that if you ever do have to call to try to fight a chargeback, the credit card, there's at least a chance the credit card company will see you as their customer. That's number one. Number two, do not use services such as PayPal or Square if you are worried about credit card chargebacks. Now, don't get me wrong, I know they offer a lot of convenience. I have a PayPal account, and every once in a while I will let a client use it. The trouble with PayPal and Square is you do not know if the person is paying by check or credit card. You have no way of knowing, credit or debit card. You have no way of knowing that if you're using PayPal or Square. So if you do not have a relationship with American Express and someone uses their American Express and pays you via PayPal, you're going to have a problem because PayPal and Square and those intermediate services do not go to bat for you. They do not. They'll contact the credit card company on your behalf, but they will not fight the battle. The minute there's any resistance, they're going to come back and say, sorry, we can't do anything for you, because they don't want to get involved in fights. They do not want to they don't have dispute resolution people who get paid hours and hours and hours to resolve little payment disputes. They don't want to get involved. That blows their whole economic model. So those are the only two pieces of advice that I can do. And then be a very good merchant with each of your merchant accounts so that everybody knows that you're a good guy. Your reputation within the credit card company is sound. Those are the only two things you can do. I get clients all the time who have, that's one of the reasons why, frankly, I don't accept credit cards. I will occasionally take a PayPal payment if it's somebody that I know and I trust, but even then there's a risk. That's the problem with credit cards. I do not like the fact that someone can buy something, pay by credit card, and then within 90 days later say the thing didn't conform to my expectations. That's a problem. I don't like that. The laws are a little too pro-consumer, but unfortunately they're not likely to go another way anytime soon, especially here in the bloody Northeast. Madam, the question is how much do you have to pay a collection? The fees vary. A lot of it's tiered to the amount of the claim. Some collection agencies charge different for different types of claims. It's all over the boards. It's like anything else. You shop around. Try to find a reputable one. Try to find one that a lot of other people in your industry use. So if you're a construction contractor, for example, there are collection agencies that kind of specialize in construction companies. So try to use who everybody else uses. It's like everybody else. I get a lot of calls from eBay sellers because all the other eBay sellers use me. It's that same kind of thing. So try to get, that. But collection agencies, though, you got to be careful because some of them charge a very hefty fee, and they really don't do what you think that they're going to. They're not going to be your gladiator. They're not going to fight the battle for you. They will try to collect the debt, but it has to be an undisputed debt. That's why I sometimes counsel my debtor clients, the minute you get a call from a collection agency, the first thing you say is, we have a problem here. I'm not happy with what this person did. Because the minute you say that, they are required by law to stop their collection activities. Now, having said that, I do know some truly nasty collection agencies, a lot of them are in Florida for some reason, that will not stop at that. I mean, they will just continue harassing until you finally cough up the money. They're not really supposed to do that, but then are you going to fight a legal battle in Florida with a collection agency of nasty, nasty people who probably know people you do not want to know? I think the answer to that's probably no. You're not going to do that. Most normal, sane people would not do that. Be very careful. Some of these collection agencies have very unsavory connections. Do you really want these people in your life? Anyway, sir. The question is, when you file a mechanics lien on a residence, what's the time frame within which they can challenge that? The short answer is I really don't know. I think in Connecticut it's something like 90 days, if I'm not mistaken. I haven't had this situation happen, but one thing you got to watch out for: do you act as a subcontractor often? Are you a sub frequently? No. You're a general. You're the guy that actually does the work. Because one thing I do know, in a lot of subcontracts that I've seen here in Connecticut, they try to make you waive your right to file the mechanics lien, or they say that you have to wait 180 days from the date of the payment was first overdue. They want to try to act and try to broker the situation in a lot of cases. So be very careful. That's very kind. Even in some of the boilerplate forms, I've seen that language. I'm sorry?
Don't they expire also?
No. The mechanics liens do not expire. In fact, that's the reason why you want to file a mechanics lien, because, quite frankly, it's recorded in the land office and it's like a lien on the property. So when these people go to sell 5 years from now, that lien has to be removed, and that's why you do it, is to get it on the land records. Question is, are you at any disadvantage if you decide to sue the person rather than file the mechanics lien? Does that disadvantage you in some way? Why not file the mechanics lien if you're legally entitled to do it? Because, not for that reason, but just because, it shows that you're serious about it. If you don't file the mechanics lien and then sue the person in court, there's a little bit of a credibility issue. The first question the judge is going to ask you: why didn't you file a lien on this property? What are you worried about? Where's the weakness in your case here that you're not telling me about? That's what's going to happen. So you.
It'd be nasty at the end too. That threat of
Yeah.
mechanics.
Well, especially if you know that the people are going to be looking to sell within a reasonable period of time. That's why they always have the new kitchen put in 3 months before they put the house up for sale. Really, the threat of a mechanics lien is very effective. Even just the threat of it saying, look, if I don't receive payment by the end, I will have no. The greatest language that I like when you're trying to collect is, if I do not get payment by X date, I will have no choice but to. Write those words down. I will have no choice but to. You're not saying you will. It just says, you're not giving me any choice. I'm going to have to get an attorney. I'm going to have to get nasty here, which is 100% accurate. You have to be careful. If you threaten a lawsuit, if you say, I will sue you, I will have the case filed in Superior Court in 3 days, you have to be prepared to follow up on that. So I would suggest you don't do that unless you have an attorney there with the papers already drafted, ready to go. And that could be a good thing to do. I have clients who will say, I've got my attorney already, we got papers ready to go, and if that's the case, but whenever you make a threat that's that specific, if you're not really prepared to make that threat because you don't want to spend the money, I will have no choice but to is the language of choice. If you look at any of my demand letters, I will always have that letter in there, because I always want to buy, because let's face it, my clients chicken out. They come on, all blazing guns and stuff at the beginning, but then the minute there's any resistance at all, they all kind of back off and turn into kittens. This is what happened. I have that issue. So I don't want to be the one hanging out there with a demand letter that says we shall do this when, in fact, the client, decides to change their mind. So I always say we will have no choice. In fact, if you're ever served with a letter like that, look at the very last sentence and see what it says. If it says we will have no choice but to, well, then you know that they're not really that excited about going to court over this. Okay, the question is, if you've done all the work and everything's been completed and you've rendered your invoice, is it true that there is a statute of limitations? I don't know what it is. I seem to remember it being 90 days here in Connecticut. I'm not 100% certain. But any attorney who does work in the construction field can look that up and answer that question for you in 5 minutes. You do have, the idea is that if you haven't been paid and 6 years later you file a mechanics lien, come on. At some point, you are deemed to have written this debt off in some way. So that's what you want to do. Of course, what you try to do is you try to get payment all throughout the process, Most contractors that I do say that, you know, payment will be due upon substantial completion, and substantial completion is a defined term. You actually say what that means. You know, and yes, I will. If you send me a punch list item that has less than 5 items on it, that is substantial completion. I don't have to complete all 5 of the little tasks. That money then becomes due at that point. You want to be very clear. Construction contracts are horrible about this. Seriously, even some of the AIA forms I don't like. You know, the standard forms that the builders use. I don't like a lot of those forms either. I want to see very precise. Here's the deal. When I have completed these tasks, other than a punch list item not to exceed 5 items, that payment becomes due, you know, net 30 days or right there. I have contractors who want that money, you know, at the very end. Okay, and having that little punch list, by the way, is also a good idea to kind of hold something over them. What a lot of contractors will do is they'll say, okay, here's the deal. You know, you pay me today for everything. I'll do the punch list items at cost. You know, that's their little way of saying, I want my money now, and if you do that to me, I'll give you a little something in return. A lot of this is negotiable. You know, you can negotiate time of payment. Have you ever gotten a bill? I mean, this is one of the oldest things in the world. Net 30, 2% 10. That's one of the oldest phrases, I think, in business. It means the bill is net 30, but if you pay within 10 days, you get a 2% discount, right? That's certainly a legitimate way to bill. And I know lawyers who will bill that way. They will say, my bill is so much, but if you pay me within 10 days, I'll knock something off. And of course, it's still, you're still getting a nice return on the deal, of course. Don't cheat yourself here. But give your debtor a little something. Give him an incentive. Again, your goal here is to get from pile 3 to pile 2. If you're in pile 1, you got nothing to worry about. Or most of the time. I mean, sometimes companies still go under and the people in pile 1 don't get paid, but it's not a very common occurrence. The pile 2 people is where you want to be. And it's very hard, because looking at some of you, I can see that some of you don't consider yourself pile 2 people. But you're going to have to start becoming a pile 2 person if you're going to start collecting things. And you got to send the signal, you don't mess with me. That's why when I take on a client for the first time, I always ask for money. I will not take on a client unless I get at least a little something up front, because I want them to know, you know, this is our relationship. I'm going to do some work for you, and I'm not going to, you know, I'm not going to ask you to prepay for everything, but I want to know that we have an understanding. This is a business relationship, and I expect to be paid. And after all, if I don't get, and I joke about this, I have a sense of humor. A lot of lawyers don't, and I think lawyers should have a better sense of humor. We do a lot better with our businesses if we did, and I'll wrap this up. I use my sense of humor. So, for example, I would say, look, don't worry about it. If you're a little late with the payment, I'm a lawyer, and I know where you live. Most people get the humor in that, you know, precisely. You know, or just, that's the other quote that I will share with you. It's a very good quote, too, especially if you're in a business like mine, where you're not always in control of your time. Whenever a client calls me and I've been a little late getting back to him on something, I'm always saying, don't worry, Joe, you're not being ignored, you're just being prioritized. That's a great line, and most clients laugh. They get it. They understand. You know, I'm like Willie Nelson. You're always on my mind. I haven't forgotten you. Don't worry. You're not being forgotten. It's just that right now you're not number 1 at this moment. But don't worry. I know your deadline, and your deadline will be met. You know, I will always give you the reassurance. If I know you have a deadline, I will always meet your deadline. But every once in a while, you know, the juggling gets a little intense sometimes, especially on April 14th. You know, when I've got literally every CPA in the state of Connecticut is calling me with some last-minute tax question that nobody knows how to answer. I have to be a little flexible there. I hope this has been helpful. If nothing else, it gives you a framework within you know, to look at this, and then I'll hang around for a few minutes.